So here's a question for you. Is there any justice in Colorado? We're diving into a case where two official court records seem to tell completely different stories. You have one document from 2015 that says a financial support order couldn't even be entered, and yet over the next decade, the state managed to collect over $100,000. So how on earth is that possible? Well, we're going to break down this absolutely perplexing legal case. And this is the number right at the heart of it all, $135,690. That's what a forensic audit says was collected from the petitioner over years. But the real question here isn't just about the money, not at all. It's about whether the court ever actually issued a legally valid order that would have authorized those payments in the first place. And boom, here it is. This is the piece of evidence the petitioner's entire case hangs on. It's a direct quote from an official court minute order dated June 10, 2015, and it states, clear as day, that the court was unable to enter support orders. So think about it. If the court itself put in writing that it couldn't issue an order, how did a six-figure debt just appear? That's the central mystery we're getting into. This leads us to the petitioner's core argument. They're saying all these financial collections were based on what they call a phantom order. Basically, an administrative entry that looks kind of official, but is missing the one thing that actually gives it legal power, a judge's signature on a formal ruling.
Okay, so what you're seeing here is the direct contradiction the petitioner is pointing to. On the left, you've got that official 2015 court record we just talked about. But on the right, that's a court register entry from 2022. The petitioner alleges this is the phantom entry, just a clerical note, no judge's signature, that was somehow used as the legal basis for all that financial enforcement.
Now, to really get what's happening, you have to understand this crucial legal idea, avoid judgment. See, this isn't like a ruling that's just wrong and you have to appeal it within 30 days. No, avoid judgment is considered a legal nothing from the moment it was created. It has zero legal force. And, critically, the argument is you can challenge it at any time. And that really gets to the heart of this legal chess match. The court recently tossed out the petitioner's challenge, pretty much saying, sorry, you missed the deadline to appeal. But the petitioner's response is incredibly simple. How can you be late to appeal an order that, in their view, was void from the start? If it never legally existed, they're arguing those procedural deadlines just don't matter. So, in response to that dismissal, the petitioner has put together this complex, multi-pronged legal attack. It's basically designed to challenge the ruling from every possible angle, making sure that if one door closes, other pathways are already wide open and moving forward. All right, so the first and most immediate move is what they're calling the primary circuit breaker. It's a formal motion for reconsideration filed with the very same judge. The whole goal here is to force the court to stop talking about procedures and deadlines and instead rule directly on the evidence, specifically that 2015 document that says no order could be entered. Just look at this timeline. It shows the incredible pressure the petitioner is under. I mean, the deadline for that motion to reconsider is November 16th, but they are not just sitting around waiting. They are simultaneously preparing a federal lawsuit and a state appeal. This isn't a step-by-step strategy. It's an all-out, all-fronts-at-once approach. And here are those parallel strategies laid out plain and simple. Pathway 1, if the court denies the reconsideration motion, a state appeal is locked and loaded. Pathway 2, at the same time, a federal lawsuit is being launched to argue that fundamental constitutional rights were violated. And then there's the third path, the most aggressive one by far, which involves referring the entire case for a criminal investigation. Right, so the federal case is meant to lift this whole dispute out of the weeds of state court procedure. The petitioner is arguing that taking over $135,000 without a valid order is an unlawful seizure of property. That's a Fourth Amendment violation. They also claim it's a denial of due process under the 14th Amendment, which is supposed to guarantee everyone a fair hearing before their property can be taken. And that brings us to the petitioner's most, explosive strategy. They're not just saying there were legal errors or that somebody messed up the paperwork. No, they're alleging that the creation of this phantom order and collecting money from it actually constitutes multiple felonies under Colorado law. So let's be clear.
The petitioner isn't just saying a mistake was made, they are alleging serious crimes. As you can see here, the allegations include abuse of public records, which is basically creating a fake entry in the court system, and forgery for pretending it's a real judicial document. They're even alleging criminal impersonation, arguing that someone acted with the court's authority when they didn't have it.
And the heaviest allegation of them all is felony theft. In Colorado, if you steal over $100,000, that's a Class 2 felony. The petitioner's logic is really straightforward. If there was no lawful order authorizing them to take the money, then taking that money wasn't just a procedural mistake. It was, in their words, theft. You know, this whole case really seems to boil down to this fundamental clash between following court rules and looking at the documented facts. And it makes you ask a much bigger question. What's the point of our legal system if its own rules can be used to sidestep basic issues of fairness? Due process isn't just some legal jargon. It's supposed to be the bedrock of our entire justice system. The 14th Amendment and the Colorado Constitution both guarantee every single person fundamental fairness. That means getting proper notice, having a hearing with an impartial judge, and getting a decision based only on the evidence. The petitioner is claiming these basic rights were just thrown out the window. And this takes us right back to the judge's recent decision. The judge didn't actually rule on the evidence. They didn't say the 2015 document was wrong or anything like that. The whole case was dismissed based on what the judge called the wrong procedural mechanism. So now, the petitioner's entire multi-front strategy is designed to do one thing: make that evidence completely impossible to ignore. So we're left with this massive question. This case presents a really stark conflict between what a court document says and what happened next. It forces the system to decide what's more important: sticking to procedural timelines or fixing what one person alleges is a massive injustice, all rooted in a legal order that might not have ever existed at all. The answer to that is going to say a lot about what justice really means in Colorado.